Hi everyone, welcome to Legally Yours. I'm here with the wonderful Donna Ross from Donna Ross Dispute Resolution Services. Thank you for joining me today, Donna.
Hi, Karen. Thanks for having me again to make another recording on something really important to me, which is mediation advocacy.
Absolutely. So look, in this interview, we're going to talk about the top tips on representing your client in a mediation. So I guess my first question to you, so how is representing clients in mediation, say, different from representing them in litigation or arbitration?
It's completely different, and unfortunately, that's not always very well understood. Some lawyers are very good at it, and others have just been taught to litigate, and they don't really know how to represent clients in a mediation. I guess it's important to just mention from the outset that mediation is very different from litigation, because mediation is a process where you're looking for a commercial resolution. You're looking to find a solution, a win-win if you can, that everyone can live with and hopefully be very happy with. So it's not really driven by the law as much as litigation is. And also it's really a negotiation, and it's trying to best negotiate to find a solution together, because that's really what it is. It's a facilitative process where the mediator facilitates an outcome, but the outcome is the party's outcome. So while lawyers are really important in mediation, and yes, I will speak a bit about the law, what they really need to do is to help the clients, especially when there's an ongoing relationship, to be able to achieve something that's commercially relevant, that's cost effective, that's important, and not necessarily just a legal win.
Fantastic. Thank you. Thank you for that. That's really really helpful to distinguish that process. So how would you recommend to best prepare then for a mediation?
Just a second, if I may, Karen. I mentioned litigation, but for some people who aren't as familiar with dispute resolution or alternative dispute resolution, arbitration is really a process which is similar to litigation and not facilitative. It's what we call determinative. So arbitration would be more similar to litigation, which is why mediation is different from both.
Okay.
So now coming to your next question,
Yes.
how
best to prepare, yes.
So it is important to know the law. As a lawyer, it is important to know the law. It's also important to really know the facts. The facts are important, and your client's needs and interests. We'll speak about some of the principles, and it's really looking at interests and not positions. What is your client's interest? Is your client's interest to go to court and fight a legal battle, especially now with the courts closed, and time to a decision even longer? Or to find a solution which will enable the businesses, the clients, to turn the page and move on or continue to work together. So really the interest, digging in, and often the clients don't know that. They don't realize they want to fight too. People get entrenched in their positions. So to best prepare is to really prepare. I always speak about prepare, 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 and to do it early. Early preparation, early mediation, before people get too much into the fight, as it were. Okay. And to look for potential areas of agreement, what might work once you get into the mediation, and not just why we're right.
Absolutely. So some of the principles that you suggest that to be applied, what are they?
Well, I mentioned the interests, looking at interests and not positions. It's separate the people from the problem. But it's really also about building trust. Building trust is so important. When people get into a dispute, then they're really at loggerheads with each other. Lawyers can really help to manage that, or they can hurt by jumping in and fighting for their client. And with the best intentions, if you fight too hard for your client, well, then the result might not be the best. Because again, remember, mediation is facilitative. It's coming to an agreement. Yeah. Active listening. We don't listen. When other people speak, we're just trying to figure out how we're going to beat them as lawyers a lot of the time. What's our best position that we can put forward? So to step back and listen. And then one thing I just mentioned is BATNA, not to give too many acronyms, but this is one that's very well known from the Harvard School. It's the best alternative to a negotiated agreement. When you go in, and we teach this in mediation, accreditation, and conflict resolution, you need to know, what's your fallback position? What happens if you don't settlement? What's your cost of non-settling? So that you know how far you can go or how far you can't go. And then you also have to try to figure out what the other side is. And that's how you can move towards an area where there is an agreement.
Absolutely love it. And it is quite a different mindset to, like you say, litigation and arbitration, where it's about almost the fight for your client. This is quite a different shift in mindset. So you've mentioned a couple of things to avoid. Anything else? So obviously making sure that you listen and you don't come in with a combative attitude would be the two biggest things. Is there anything else they should avoid?
Well, yeah, yes, there is. And what you mentioned is really important too, because in litigation, it's just the law. And while knowing the law is important, what happens if, you really need to look at what is the commerciality of the dispute and of the solution. Also, avoid posturing, using power plays, making insulting offers. I always say when I'm a mediator, when people say, this is my final offer, I say, I don't do final offers. But it's true, when you come in with a low ball offer or a final offer, it creates more distrust and more anxiety and more of a combative nature, as you just said, than moving towards a resolution. And don't use mediation as a litigation tool.
Okay, it's such good advice. Well, Donna, how can people get in contact with you to access your services if this is the mediation routes where they're going?
Well, obviously through the Legally Yours website, and also through my website, DonnaRossDisputeResolution.com. I'm happy to come in to law firms, or perhaps do it virtually now, to do mediation trainings or negotiation trainings, and would be happy to give a discount even to the Legally Yours people, because I think it's really important to know how to best manage client expectations in your own in mediation. If not, you're really doing your client a disservice if you litigate in a mediation. And you know what? These are principles that come from the Harvard School of Negotiation, and they can be used not only in your legal practice, but really in every walk of life.
Absolutely. Well, thank you so much. It's so informative as per usual, and for that information. And thank you so much for joining us, and thank you for watching.
Thank you, Karen.